you who have not been in one of the sessions in this room yet today, my name is Amanda Howell-Price. I'm a workforce training coordinator here at Southwest Mississippi Community College, so welcome to our Regional Workforce Training Center. We're happy to have you today. We have three presenters I'm going to introduce, and it's a mouthful, so just go with me. All right. Glover Russell, make sure I got that right, began practicing law in 1982 in Jackson, Mississippi, and has developed a practice consisting of estate business and tax planning, wills, trusts, and probate. He started Glover Russell, PA in 2003, which has grown to 4 attorneys. Previously, Russ was a partner at Magruder, Montgomery, Rocado, and Postman, PA, Phelps Dunbar, LLP, and Watkins, Ludlam, Winter, and Stennis, PA. He received a BBA degree from Delta State in 1977 and became a certified public accountant in 1979. Thereafter, he received a Juris Doctor cum laude from University of Mississippi School of Law in 1981 and a Master of Laws in Taxation from New York University in 1982. He's married and lives in Jackson, has 2 sons who also live in Jackson, a daughter, son-in-law, and 4 grandchildren who live in Centerville. Next we have Erin here on the end, Alford, who has been with Glover Russell, PA since September 2012. She graduated in 2009 with a Bachelor of Arts in Psychology from the University of Mississippi, and in May 2012 graduated with honors from the University of Mississippi School of Law. During her undergraduate studies, Erin gained experience in banking and real estate transactions, and she gained legal experience clerking for a law firm in Batesville during law school. And then we have Ms. McCall Stern, who has been with Glover Russell, PA since April 2007. She received her Doctor of Jurisprudence, as a mouthful, in May 2013 from Mississippi College School of Law, graduating magna cum laude in the top 10% of her class while continuing to work with the firm and raising 2 beautiful children. McCall previously worked as an independent lobbyist and consultant and is very active in community service. So I'm going to turn it over to them.
There's been a pop quiz and all that.
Yeah.
Well, good afternoon. We're glad to be here today, and what we're going to do is probably do it more of kind of a town hall format. I'll sort of be the moderator. McCall will discuss some, Erin will discuss some. We'll certainly want to take questions. Estate planning is very, as y'all know, it's a broad topic, and there are just a lot of areas that we will need to, we'll try to cover, that we think is interesting for y'all, and that would be somewhat tailored towards this TMS oil play and the gifting and the death taxes and things of that nature. Not so much income taxes, I think that's been covered earlier. And then some planning techniques that go along with that as well. And then some pitfalls that you may find along the way. We know that what y'all want to do is pass on as much as possible to your family as this oil play comes in, and it's going to last forever from what I understand. The clients that we are working with, some have large interests, some have 1/2, for instance, net mineral acre. They have a few more than just the 1/2, but it's so fractionalized. I mean, there's just, as y'all know, it's just a lot of different acreage. Very few people seem to own hundreds and hundreds, though there are out there, of acres, of mineral acres. They may have a lot of surface acres, but the mineral acres, have been fractionalized. And so what we want to do is try to encapsulate some oil and gas, plus just estate planning, plus some of the surface interests as well in all of this.
But see, estate planning is not something people want to talk about a lot. And that's kind of one of the first things we want to get into is why we need to worry about it now. Because there's so many things going on in your life. You've got business stuff and stuff with the kids and grandkids and all of that. Why is it important that we think about that now?
Mm-hmm. And well, it's important, one, because you have capacity. You know what you have, what you may be getting in the future, and so you're able to address it at this point in time and then fine-tune it as life goes on. Years go by. You see how the oil and gas interest plays out. You see how your children are going to do. In the old days, it used to be taxes drove a lot of estate planning, estate taxes, that is. Not so much now. The exclusion from estate tax is $5,340,000. So if you have $5,340,000, you'll owe no estate tax. If you're married, your spouse has $5,340,000. So it's $10,680,000 that you can pass estate tax free without any government intervention in taxes. Now, we don't know how long that lasts. You'll be here for quite a while, but that has nipped a lot of the concern for a lot of people in the bud from an estate tax standpoint. But there's still a lot of other issues associated with estate planning in addition to just estate taxes. And taxes, that shouldn't be driving the boat, I don't think. I think really the first thing, and always should be the first thing, is the family. How you want your assets to pass, how they should pass should they go out right. And we'll talk more about this. McCall will talk about some of that, and we'll get into a little more detail. But there are those issues that get into estate planning. Asset protection, how to own them, trust, limited liability companies, limited partnerships, things of that nature to help asset protect from creditors and things of that nature. In planning, what you want, it's a combination of a number of things. You have business planning, whether that goes into this, you have family planning, you have succession planning, and all of these different issues from a planning standpoint all meld into your estate plan. And a lot of what we've heard today from the different disciplines and the guys talking, all come together for an estate plan. You look at all of this, you look at the ownership interest. Hopefully you know what you own now. It's a lot better to know now than to find out after the fact when somebody's passed away and then you come in and try to probate an estate. You're not sure where the assets are, who owns what. It's much more expensive. So it's much better to do all of that now and plan how you want it to pass to your family members or charities or things of that nature.
So if you're like me, I hear all of that and go, that's way too much. I don't know what to do today. And that's where you do need to seek out an advisor and start planning now. It's a lot simpler if you plan now and go in and get basic things set up, and then you can work on things further. But you've got to set something up now, and there are gifting things that you can do now for the exclusion amount if you are concerned about being over that $5 million, etc. But the point is you've got to do it now and not be so overwhelmed. You've all been in several different seminars today, heard from all different perspectives, all these things that are out there. And what I really want to stress is that you be proactive and you at least sit down with a trusted advisor and get the basics handled and then move forward, because what can happen if you don't?
Yeah, and that is the thing. Plan now. You have the capacity to plan now. And like Russ said, higher taxes has always been on the forefront of planning. If you do have an estate that's over $5 million, the tax rate will be 40%. And a lot of people don't want to give the government 40% of.
Is it 40% over the whole thing, or just 40% over the part that's $5 million?
It's 40% over the $5 million.
That's correct, yeah. And so that's a major issue for a lot of people. And then you've got, if you don't plan, if you don't have a will, if you don't have, a trust set up, and, a number of different things, you could have unintended beneficiaries. So if you don't have a will, the state's going to decide who gets your assets, who gets your home, who gets your money, who gets, anything and everything. And a lot of people don't want that. So it's very important that you decide, you plan. And then when you do have a unintended beneficiaries, it kind of evolves into family conflict. You don't want your kids or your grandkids or, your siblings, whoever it may be, to fight over what you leave behind. You want to have that plan, and talk to them, and so everybody knows what you want to do. And then, if you have family conflict, a lot of times that leads to unintended expenses. If you have people fighting over things that you leave behind, if they don't know how you want things to go, that will cause a lot of legal bills. And people don't like to pay a lot of legal bills, But, a lot of those things happen after you're gone. Some things can happen while you're still here, if you don't plan. You can come across people who want to take advantage of you. If you don't have, things in place, you have unscrupulous individuals who try to take advantage of you in your older age. If you have a power of attorney, even if you have a power of attorney in place, it's kind of a growing concern, the elderly getting taken advantage of, and assets getting transferred, bank account names getting changed, and then you also want to think about long-term care. A lot of times people run into not having planned for their future, for their retirement. Nursing home facilities are outrageously expensive. Sitters, you got to think about all those things and plan for that. And if you don't, you run the risk of leaving no legacy for your family. Those are the kind of things you can run into if you don't plan.
It seems that there's more and more of is conflict within the family. Over the years, it didn't seem to be as much, whether it's children or nieces and nephews or siblings. But that seems to be changing, and as there's more money, there seems to be involved. There seems to be more conflict, and conflict seems to go just across the board, whether it's abusing, and we'll talk about some of these things later, powers of attorneys, or trying to convince somebody to change a will a certain way, or just getting on accounts with somebody and the other folks don't understand the consequences of being on accounts with other people or on deeds with other people. So there seems to be, there's just a lot more of that. And the less planning, it seems to be, the more there is of that goes on. And that's unfortunate. And so that's something that just is really a concern for us. And then the other thing is an unexpected illness. Everybody thinks they're going to be healthy, and then they get sick. Or something happens to them, and they're no longer capable of preparing a will, or changing the will, or the power of attorney, or revocable trust. And so, even though everyone thinks they're going to live forever, that's what we want to do, it doesn't happen. And that's another concern in postponing things, especially when you have large sums of money, a lot going on. It's all relative, I understand that. Unexpected illnesses happen a lot. And so, and that really makes it difficult. Once somebody becomes disabled, you're not going to change anything, or that person can't. And so, that's a big concern as well.
And just, on the, what's the worst that can happen? One thing I do want to stress is that you do talk to a professional advisor, someone that you trust that is knowledgeable. Have your financial advisor, your attorney talking together. The worst thing people do that we've seen is getting on the internet or some forums and trying to draft legal documents themselves. The most expensive estates we've had to probate are when someone did that. And the reason for it is there are everyday words that may not mean a whole lot to just a person that doesn't know the legal implications of those words. And they can have significant effects. We had one lady that, deceased who, brilliant woman, just changed a little wording and messed up the entire estate plan to where all of her assets went out of her estate and into an entity that wasn't intended. So there's so many things that can happen if you don't know the legal implications. Power of attorneys, you may think those are simple things, but there's such a broad spectrum. There's not a one form fits all. And you want to be sure you know what powers you are conveying, how broad those powers are. Make sure that the person that you're appointing knows the fiduciary responsibilities tied into that. They're saying that, I would like to think, oh no, well, my family, everyone gets along. I have to deal with it personally whenever my grandparents have passed or people have gotten ill in my family, that, your family's not immune from the conflict. And it's not always a self-interest thing. It can be differing opinions about what is best. But if you have a plan in place, you get to make those decisions now. So if something comes up in the future, you've already made the decision. And we can talk about some of the planning tools later, but
And just talking about it with your family, so everybody knows, not just the person you name in your power of attorney, or the executor you name in your will, so everybody knows that there's not a huge conflict down the road. And those powers of attorney are very, very powerful.
and that's all I like to talk to you about is, death is not something we want to consider a lot. Incapacity is not something we want to consider a lot. I look at it as choices. And you have the choice to either make your choices now and have those recorded, or someone else is going to make choices for you. And it may or not be the best thing. So it just gives you your control. Don't think of it as a scary thing, but it's a control thing. You want to make sure your choices are in place. Because if things hit the fan, who you trust to make decisions for you, or what decisions you want to be made.
Yeah, that's true, and there's always somebody out there preying on folks. And in this particular situation, with all the potential revenue that's coming in, whether it's bonus payments, lease payments, or whatever it may be, there's just a lot of that to be aware of. And I think talking to whether it's your accountant or to your bank loan officer, your bank officer, just to be aware when something sounds fishy, talk to somebody else, or your attorney, whoever you confide in. That's a good place to start, because we hear war stories now about things happening out there, and hopefully none of that's happened to you, whether it's selling your mental interest or participating in some LLC or something of that nature. Just be sure to ask questions. There's just a lot of downside to it if you're not prepared. And I think what we probably want to do now is go into some of the, any questions?
Y'all together?
All three together,
Same office?
same law firm.
Okay, this is a product you sell to us, that your services is a product that you offer this plan?
Estate planning,
Yeah, here's a plan for Joe Doe.
now it's very individualized.
Yes.
Very fact intensive, based on the person's particular needs, financial needs, whether there's handicapped children, special needs, net worth and things of that nature.
But
Yes.
the service, if I understand it, correct me if I'm wrong, for a fee, and I'll ask you what the fee is later, but for a fee, I do a data dump to you, financially undressed, and tell you everything, and then you give me a plan back to.
That's
My
tailored.
favorite word is fiduciary. If you can offer a fiduciary service, cold eyes review, this is what you need to do in your humble opinion. So what you selling? Pretty much.
That's what we
They
do.
do.
We
Right.
practice in estate
just-
law.
You give me a work list of information you need, and I give it to you.
Yes,
I come
yes.
into your office, and
Correct.
you just cold eyes, this is what I do, this
Yes.
is what makes sense.
That's correct.
And I give you a check, and it goes out.
That's correct. Yes, what you would normally do from an estate planning standpoint is we would ask for a list of your assets.
Okay.
And that would be, for instance, bank accounts, savings accounts, brokerage accounts, retirement accounts, deeds, mineral surface acre deeds, mineral acre deeds, anything like that. If you have trust accounts, life insurance policies, any debts, what debts you have, notes, obligations, and things of that nature. If you have businesses, then what you own, whether it's stock, I'm talking about closely held businesses or LLCs, we would get all of that, and then we would have you come in and ask. We would then question you, what do you want to do with your assets when you pass away? Who do you want to leave them to? How should we leave them, whether trust or outright, things of that nature? Are there any special circumstances we would need to be aware of? And then, based on that, we would prepare the documents for you. And that could be any number of documents, depending on the direction we were going in. It simply could be a will, power of attorney, advanced healthcare directive, could be an LLC to put all of your mineral interest in because it's simpler to transfer. You don't have to change as many deeds and things, and make gifts with it, and we'll talk more about that for discounting purposes, so you can give away more. And that's all for a fee, which we would attempt to estimate on the front end, but it's like building a house. If you want a small house, it's not as expensive. If you want a big house, it's going to be more. And if we start the foundation as a slab and you come in after we've poured it and you want a conventional, well, it's going to be a whole lot more because we're going to tear it up and start all over again. So that's how we generally do prepare somebody's estate plan like that, and then advise them as we go along as to what they may need to do or consider in the future going forward.
I work a lot with people's other, maybe financial advisors, CPAs, et cetera, because there is, and that's, you can do the form route, but it's not tailored to your specific needs. And that's where what we do is very individualized in looking at your needs, your long-term goals for your business or for your personal life, family, long-term care planning needs, things of that nature, and then also your legacy concerns, but taking that together and working a plan that works for you. And, you know, even if you have a plan in place, you want to revisit that on at least, let's say, a biannually basis to make sure nothing's changed, make sure things are still up to date, things of that nature.
And what we're doing more with the clients and families down here is it seems that a lot of people don't, I don't say understand, but what do we have? We do spreadsheets now that identify the mineral acres, the surface acres, the percentage you have, whether in the unit, if you've unitized, and spread it on out, and do that for all the mineral interests that, if you have one, then it's pretty simple, one line. It seems like a lot of people may have a page of mineral acres. Now, it doesn't have to be 100 acres on each line of the spreadsheet. It may only be 1 acre, 5 acre, 10 acres, or maybe 100. But it helps, it seems, it helps a lot of folks understand what do we have, what's the potential. And so as part of all this, and certainly we don't have to, but it seems to me that a lot of clients like it, where we help organize what they have and help them understand where their investment, their oil and gas interests are. We get copies of the deeds to go with it, the leases to go with it, and all of that, whether it's Aaron and I are working on some now that's the heirs are the clients are alive, and so that makes it a lot easier. You talk to
them and ask them, you know, what's going on, and then it's a lot easier to figure that out on the front end than it is on the back end.
Yeah, I mean, we're running into deals like on the federal land buying.
Sometimes it's not easy, actually.
Well,
but,
yeah.
You know, it's time consuming, those land record searches, so.
Because
Yeah.
your operators
Yeah.
aren't gonna necessarily, they're not gonna spend as much time as a landowner. The operators look at it like, we're gonna do what we need to, we're gonna figure out who we think gets what they're supposed to get, but we're not gonna guarantee anything. It's the landowner that's supposed to keep up with that. And so.
Your leases will have usually a line in them that say you're guaranteed you own what they think you own.
Right, and if you don't, you get to pay it back.
Yeah.
Now, they'll ask you to pay it back, now you can fight them about it, but no, that's not, we're not going there. But we're running into this issue over in the Mid-County with the Federal Land Bank, and these transfers back and forth with the Federal Land Bank, the United States, then the Federal Land Bank again, and whether there was a taking by the U.S. government from the Federal Land Bank. So there are issues, reinvesting, and so.
But that's easier to take care of while the client's still alive versus having to dig an old desk, trying to reassemble things and put things together after the fact.
And that's what we're doing this on some clients that McCall's working on, where we've got deeds and descriptions that the operators didn't know about, so we sent it to the operators, who now are having to redo and recalculate the ownership interest, and then they overpaid us because they thought we had more than we did now, so we just told them no, we didn't, and they're gonna redo that and some others, and so these operators, they do the best they can, the landmen do, but they're not gonna do everything. And when the client's passed away and you're representing the surviving spouse, let's say, and that's the case, the one that's in really bad shape, that's not right. It's not bad shape. It's just the husband didn't explain to his wife what all he had. And he was a geologist, so he has mental interest all over the place, and we're having to go back now and try to,
Hunt them down.
yeah,
So to speak.
and recreate and figure it out. And it's much more expensive and complicated. And then you worry, do we have everything? So we have to draft these deeds that are really broad and report them in a lot of counties to make sure we cover things in case the operators come in and want to drill or lease. They'll at least find something and then hopefully find our client through these broad deeds. So that, back to your question, that's kind of what we do as far as trying to help clients keep up with understand what they have.
Is it a written plan that's something that's a living document, or is it a turnkey, see you later, or?
I mean, no, it depends on the type of tool that you use, and that's where, point up there. Stuff like a will or trust, that is a living document. Now, that you can take with you, it's in writing and it has a legal effect. And until you revoke it or modify it, that document will control.
Okay.
If there's other things you can do that may be just advice on how you proceed with something.
Okay.
So it depends on what your individual needs are. And we'll usually do a consultation with clients and just talk to their potential clients and talk to them about what their needs are and see what you need or may not need. Does that make sense?
Yeah, you said something about long-term care. You suggest I need it, and I say I run the number 20 times and I don't need it.
Then you don't need it.
You go on to the next item. Okay,
Absolutely.
you talk about this item and then.
And the thing with long-term care, and that's something that I'm having to deal with on a daily basis right now, with my grandfather and taking care of him. And assets that you may think are sufficient to cover when you look at the cost of sitter care and assisted living and the ancillaries that come up, it adds up quickly. And that's where it's important, not that you buy a long-term care insurance policy. Not saying that's the answer, or not that you do any particular one thing, but making sure that you're thinking about it and having your attorney talk with your financial advisor, being aware of what type of benefits are out there and what you may qualify for long-term, whether you're a veteran. That, there's certain benefits out there that aren't widely known for long-term care, or whether it's putting assets in trust and planning and making sure that those assets are going to last, whether it be investments, whether it be insurance policies, whether it be trust. There's no one answer.
Well, speaking of veteran law, my father had a trust. He was a veteran, we had to put him in the VA home, because of, take care of.
Right.
They couldn't touch the trust, the VA, or take any of the money out of there because of that.
So there's things you can do today that make a big difference in the long term and can give you, it may be 50 years before you have to ever worry about it. but having the peace of mind that your family's not going to have to worry about it, and you're not gonna have to worry about it, makes all the difference in the world. I mean, that's, the peace of mind to me is the biggest thing. Because I've dealt with family members that planned, and that was easier. You know, and I've dealt with family members that didn't plan. And even though there's no one within the family fighting, there's so many complications in trying to resolve those, and finding assets, and figuring out debts, and all of the things that come up that we don't think about, you know. Think about your email. Do you get paper statements on everything, or are things emailed to you? And I don't know if people use that, but that's where things are kind of going. And if there's not someone that you're talking to that knows how to find the information, if something were to happen to you, and your statements are going online, say, and you're not getting a paper copy at home, how's anyone gonna know that that's there? You know, there's just a lot of little considerations that talking about it is well worth it, even if it is a little uncomfortable sometimes.
Could you talk about will and trust versus a trust, and a little about the pros and cons of each?
Yes, and then one thing, before we do that, if I may, on the long-term care, like McCall was saying, it doesn't necessarily have to be an insurance policy or anything of that nature, it's just planning for that. But what a lot of people will call about is they want to get on Medicaid. And how can we dispose of our assets to get on Medicaid, you know? So we, the government, will cover the nursing home care or something of that nature. Well, you end up having to give away so much that most folks really don't want to do it. And I generally say, you don't want to live in a nursing home or a facility that just takes Medicaid patients. I mean, people can get, you can do that. But most folks, when they think about it, that's really not what they want to do for their parents or someone in that situation. But long-term care is just planning ahead for that point in time where you don't want to be dependent on your children.
And planning ahead so you don't have to depend on Medicaid,
And not depend on
you
Medicaid.
know? I mean, ideally, you wanna have enough to take care of yourself long-term and not have to depend on, you know, the government to do it for you, so. I mean, that's where you plan and save and do all that so you are able to take care of yourself.
So, and then just the other decisions, I mean, you know, advanced healthcare directives, and then we'll get into your question, I didn't mean to sidestep that. You know, making your medical decisions, so that if something were to happen, your children or your spouse or your loved ones don't have to make those hard decisions. They know what you want, so that it doesn't ever come up, because those are not easy decisions to make. Even if you know this is what mama would have wanted, when you have to make the decision, you start thinking in your head, well, this is what mom would have wanted, but I can't do that, and I don't think that's best right now. And you get conflicted. And so if it's in writing and mama said no, if push comes to shove, you know, do not prolong, or do prolong. But here's my answer, and if I can't answer, here's my answer. And that way, that takes out all the back and forth in the head. Should I do this? Should I not? What would mom do? What's the best thing to do? All that's gone away. And that's where, you know, a lot of estate planning, it is financial. You know, we do worry about taxes, and we worry about all of those things. But to me, it's very much more personal in you're having peace of mind, and your family has peace of mind, and they're not put in the middle of that. As far as wills and trust,
And you don't want to have to do an advanced healthcare directive when you're dying, because that's not a comfortable situation to be in when the person's dying. And it's always good if whoever the agent is that's going to make the decision to take somebody off life support, it works in general, that's a child. It's good if the child can be with the parent while the parent's healthy, can hear what the parent wants done, and then knows when the time comes, this is what my mom or my dad wants done. Not when the parent's fixing to die. The parent knows why you're there, you have to tell them why you're there, and the child's there and knows what's fixing to happen, and you go through this, and you discuss all of this, and that's a very tough situation to be in. So it's always much better to do that ahead of time than at the last minute. That's a lot. It's a lot more to it than a lot of folks think about signing an advance bill here, correct? The question on a will and a trust, what was that question again?
What are some of the pros and cons of having a trust as opposed to a will? My mother is 88. Should she leave a will, or would a trust be better for her? I mean, I don't know which would be better in that situation.
What she would have would be, from a trust standpoint, would be a revocable trust, which would be basic, because if it's irrevocable, she's given everything away. So from tax standpoint and everything else, a revocable trust, she would be the owner of the trust, and which would require conveying into that trust all of her assets. She could be the trustee, would not necessarily have to be the trustee. And so until she passed away, she would own, in effect, the assets in the trust. The reason you do that, a lot of people do that, is if she became incapacitated, or Alzheimer's, some type of illness set in, then there would be a successor trustee that would be appointed, who would then manage the trust, and then in her passing, the trust would say how the assets would pass at her death.
Is there a tax benefit to that?
No tax benefit. Because she still owns it, there's no gift tax, no estate tax. The estate tax would occur at her death because she owns it up until that point in time. Where a will, there's no conveyance of the assets at that point, at any time until death. And so the will essentially does what the trust document does. It identifies who the beneficiaries are, who the executor would be. That is, who's going to handle the estate. And then in her death, then the will would control where the assets went. So but you probate that. Now, from a dollar and cents, from a cost standpoint, they end up being about the same. Now, what I see more is you have a revocable trust where someone wants to put all their assets in the trust to avoid probate or to plan for incapacity, let's say, but then they don't go the next step and put everything in there. So you have part of your assets over in this trust, and then part of your assets over here in the estate, so you still have to probate, you still have this trust document to pay for, and then a lot of times they don't mesh. For whatever reason, they should, but they don't. And so then you have this trust, this will, and then some stuff falling in the middle, so then it's really a lot more expensive to clean up and try to understand what was going on. It depends on what asset she has, whether to put it in a revocable trust or not. It may be you could do the same thing with power of attorney, giving somebody that power to handle their assets if she wasn't able to do that. The family dynamics make a big difference.
Ages of beneficiaries.
Yeah, age of the beneficiaries, things of that nature. So because a lot of times individuals don't want to do everything that's required for the revocable trust and to maintain conveying new assets into it and things of that nature, we don't recommend it, just because they're not diligent enough to keep up with doing what they're supposed to do.
So will, you've got it all set down in a trust, you just have to keep adding to it as you accumulate.
That's correct. For what you're talking about and trying to accomplish, that's true. Now, you could have an irrevocable trust, but that's where you put everything in it, and then she doesn't own it anymore. Now, my philosophy on that is, if it's the parents' assets, then they ought to be able to keep it, live off of it, do with it as they need. Don't worry about the kids. I mean, they need to take care of themselves. You got to worry about the parents. But you go put it in an irrevocable trust, then they've lost control, and it's the trustee that's gonna decide if mom or dad's gonna have supper tonight. And I just don't, and I don't like that, because there are a lot of children that would rather see mom and dad not have supper because they wanna go to a football game or something. But
And not that that's, I mean, their intention, but it does get harder as, and I've seen, I mean, like I said, you know, you've seen this with other clients and things, and it's not that the child generally wants them to do without, but people don't always understand completely. They kind of see elderly and children almost not as complete people at times, and not, it's just unintentional, but they start thinking, well, mama doesn't really know the difference right now. So what's the difference in her being here and here when this costs $5,000 a month? And it becomes just something you'd say with a child, well, they don't know the difference. They're just three. But you do want to maintain your dignity, and you do want to maintain your standard of living. And I don't think it's always a selfish thing, but a lot of times children, they're not the ones that are going through the medical issues and things of that nature, and it's just maybe just an incomplete understanding of what it's like to be in mom or dad's shoes, if that makes sense.
What tools would be helpful for an elderly couple with significant land holdings, royalties, who are interested in transferring their assets, but would like to preserve income from those assets for their life?
yeah,
Would that be a
Yes.
trust of sorts?
now you can use a trust for that, but you have these tax consequences. I like limited liability companies. And that's where if you have significant land holdings, you convey those assets into the LLC, and then let's say it's one person that owns all of that. That person comes out as a 100% owner of the LLC. And then, let's say there are other family members you want to own some of it. You can then start making gifts of the LLC interest to these other family members. And that's where you get into valuation issues of these units. So for instance, let's say this asset's worth $1 million. With the TMS going on $1 million, you could be 10 million, it could be a lot more than $1 million, but for math purposes, keep it straight in my head. Let's say it's $1 million. You put $1 million in that LLC. You have it valued, you have service interest value, and then the mineral interest value. And that gets into, is it commercial play, is it a wildcat play, is it unitized or not? So you look at all this and come up with the value of the mineral interest that goes into it. And time's kind of the essence around here. The more land that's unitized, the higher the value is going to be. And then once they get through drilling all these wells, by this time next year, it's going to probably be a commercial play, so it's not going to be wildcats. So everything in Wilkinson County is going to be valued at some huge number. But let's say it's $1 million, and it's not $1 million today. Then you have some children you want to leave it to. You can give $14,000 away each year. Well, it's not 1.4%. Yeah, 1.4% of $1 million. You get to discount that $14,000 gift to the children because it's a minority interest. So let's say it's worth $20,000. You get a 40% discount. So then it's only worth $12,000 for gifting purposes. So what's $20,000 mathematically is worth gift tax purposes $12,000. So with using an LLC, you get to discount the value of the asset and arriving at what is the $14,000 amount you can give away now. You get to discount it so you can give away more in value by using something like that to family members. Now, you can give all $5 million away, and that may not be such a bad thing if it keeps developing around here. What's worth $5 million? 3 years ago, $5 million would have bought, well, say 5 years ago, in counties, Goodrich and Penn. 5 years ago, $5 million would have bought you half of a mid-county probably. Today, $5 million won't buy you a section, let's say 640 acres. 5 years from now, you know, $5 million may not buy you 100 acres because it's worth so much more, so you may want to give away $5 million today. It's kind of, maybe risky if this all doesn't work and it goes away, but those are issues you think about in doing something like this where you form an entity, put these assets in, and then start gifting. Now, as far as control of income, income comes out of these things based on ownership interest. But what you do is if you've given away, say, 30% of it, but you want 100% of the income, you just charge, well, you set it up where you get a management fee and things like that, where you pay yourself, and then whatever you think should be left to divide up amongst the members, you do it that way. So you can get, there's certain ways to structure where you get the owner, the parent, the one that put the money in, gets as much cash as needed before you start giving it to, before it passes through to the other members. And there are other reasons for doing this. One is it puts all the assets in one entity. If you want to transfer, you're not changing all these deeds and division orders and all these other things, assignments that go along with it. You just give somebody a membership interest, and that's it. And then the asset's still there. You can restrict transfers of these membership interests. You have to build into it certain conditions on transfer or divorce or death or anything you want, you build it into that document to accomplish whatever the objective is from that standpoint. And then you have, it's from a management and maintenance standpoint, what I have found, having it one entity, then that whoever's in control can then maintain the whole, and you don't have tenants in common. Somebody may want to come in and hunt on it, and somebody may not want them to hunt on it for surface interests and things like that. And you can control all that by having it in there. It just makes it much more functional, and you can manage it a lot better. So yeah, the trusts, because of the gift tax issue, it's a little harder to pour a lot of money into a trust than it is to an LLC. And then the trustee is a fiduciary. And then whoever the trustee of the trust is going to be very careful about what he or she does, or it does if it's a corporate trustee, in managing that asset. Because you've got all these fiduciary duties, prudency and diversification and all these other things that go along with being a fiduciary in a trust that doesn't necessarily apply to an LLC because that's a business. So you're making business decisions, and as long as it's reasonable, that's fine. And you don't have all these other fiduciary duties that go along with the trustee situation. So you can do a trust, but I generally don't do
In
that.
an earlier meeting today, a limited partnership was brought up. How would you compare the advantages and disadvantages of an LLC versus partnership?
From a tax standpoint, they're going to be this. Well, generally, an LLC can be taxed as a partnership, and a limited partnership is taxed as a partnership. The big distinction is limited partnership, you're going to have a general partner, and then everybody else is a limited partner. And generally, the general partner has a 1% interest. The limiteds have no vote, no control, no management responsibilities. Limited partnerships you saw back in the 80s and 90s and before. More LLCs, now limited liability companies, than limited and general partnerships. I haven't, they work, I just don't use a limited partnership too much anymore, just because you have tax issues that are built into limited partnerships that you have to be careful of. That's generally more for syndications, and you see a lot of that in some of this that's going on around here, where folks are coming in and talking to the landowner and wanting to buy your interest. I know there's some where it's been pooled or not, and where you're forced to integrate it, and you come in and put your interest in there, and so they syndicate it and sell it and all. Generally, the limited partnership is for bigger deals, so to speak. than a family situation. Because once the general partner passes away, who's gonna be the general partner? And the limited partners can't vote on it. They don't have that type of, now you can draft, you can have, the limited partnership agreement can be 100 pages long. The limited liability company can be maybe 20 pages long. Because of the tax issues, limited partnerships are driven by the tax internal revenue code. So you have to be real careful on what you say and what you do and how you do it. And that's why they're more complicated. You can have them smaller, but it's just a much more complicated structure because of it's tax driven.
Back to the LLCs, we're kind of, because those are a newer creation by law, they kind of took the best of partnerships and corporations and let you kind of have an a la carte menu of designing the LLC so that you can pull the attributes that you want for your entity. And they're more recent statutory creation than your partnerships. So it just gives you a little more flexibility. But it doesn't mean that one answer is right over the other. It goes into preferences, you still have them. The LLC does, you can kind of choose some corporate attributes and some partnership attributes and tailor it to what you want.
But
How do y'all stay current in all this information? I mean, this thing's changing every day.
oh, they're changing all the time.
How do y'all,
Read.
Read,
Yeah,
well,
reading.
seminars and things of that nature.
you're out there marching point for your clients, looking out for their best interest?
Correct.
And a lot of it's working with our clients is, as things come up, we'll research it and, and you do see, we do the hand down lists that come down from the Supreme Court or anytime there's legislative updates. That's.
And then the internet makes it a lot easier nowadays. You get these treatises, the publications, whether it's CCH or RIA or BNA, they're all these tax,
And they're so fun to read.
tax.
Riveting.
Read, go to
Yeah, you
sleep.
can get.
You know what?
Yeah, I appreciate
I had a week where I couldn't sleep, I just kept taking the
How big is your
songs.
client base number-wise?
Varies. We tend to spend more time with clients and build more relationships. We don't look for mass clients.
Right.
We tend to be more, we may do someone's business merger and then a will from them and then, retirement planning and then their kids' interest. And so we tend to build more relationships. We don't have bulk clients.
Right.
How big's your office? Is this it?
And we have another attorney,
You've
this
got
is 4 of us.
4 of you? You typically see multiple clients in a week's time?
Oh, yes,
Oh,
from
yes.
that standpoint, absolutely.
But it's not like a domestic or criminal practice where you've got 12 clients you're dealing with a day.
Correct.
We are able to spend one-on-one time and actually, we make sure that we return calls that day and even if it's, say, I'll check into this, but keeping our client base smaller helps us to give more one-on-one service.
Yeah, we like to say quality, not quantity. So,
But generally what we'll do, for instance, a lot of the clients, we do their estate planning, we do a lot of their business work for them, we do their children's work for them, mergers and acquisitions, if they go out and merge with somebody. So it's more than just generally somebody coming in and doing a will. Now, if that's all they need, yes, we'll do that, but it's typically more than that.
yeah.
We've had several like that, or probates, I do a lot of those
Yeah, no,
now, and, we all have done those, and
Now, probate's
most of them
generally
forever.
done.
But
Yeah.
those are, whenever someone passes away, we help administer their estates, and, I've got some clients that are small amount, that it's just, pretty much a 6-month relationship, and that's pretty much it.
But it's
So
kinda
we've
like
had,
this, yeah.
Where he's helped executors and then helped their kids and their kids.
And I've had
I'm
clients
not old
where.
enough to do multiple
No,
generations
that's
yet.
right. I've done the spouse, the probate, the spouses, somebody my age's parents, his wife's mother and dad passed away. I've probated both of their wills and probated their estates, did their planning first for them, and then they passed away, and then the dad on the others, the husband's dad's passed away, and probated all that, and then the mom, we do her work, so when that time comes, and then the son and his wife, who I grew up with, do theirs, and then I'm sure do some with the kids, and so it's, like Paul said, multi-generation type of work. I mean, you get to know the family, and you get to know who they are, and nuances and things of that nature. And so it's,
When you probate, how do you bill? Is that hourly, or is it in any way proportional to the assets?
it's generally hourly.
Which
Now-
generally makes it proportional, just because if you have less assets, there's not as many things that come up.
Right, not as many issues.
Some states have percentage, Mississippi doesn't,
Mhm.
we just do hourly.
Now, then in some cases, I mean, it ends up being more than, well, we just might think it's justified just because of the state and just these things you get into, and so you don't bill, we sometimes just don't bill for it, all of it, just because it's, anyway, that's just our practice, that's not your doctor's practice.
We got a red pen, like, I don't want them to have to pay for that.
So if you own the business, I guess you have that discretion to do that, but that's how you're gonna do it on an hourly basis, not a percentage. But it's generally relative to how many assets you have. Now, if you've got mineral interest in 30 counties around here, and they're all 2-acre mineral interests, you run up a whole lot of legal fees trying to run that down, and it may not be worth a whole lot, and that's where you want to meet with the client ahead of time, make sure we all understand what the issues are before we go out and start running down every rabbit trail, and then they'll tell you, yeah, let's do it, let's done it. So that's kind of another thing to try to do, is stay in touch with the client, so we all know what we're doing, and don't get, have any issues there.
Not any other questions?
Is there a cap on the executive fee in Mississippi? Or is it like a reasonableness standard?
Reasonable
So whatever
standard.
the court thinks is reasonable that they charge us? Okay, okay. And then, kind of a related question, does Mississippi have any provision for like independent administration? Or
What do you mean by
are you
independent
familiar with that?
administration?
Okay. Probably 10 or 15 years ago in Louisiana, the practice had always been that when you were probating an estate, anything you wanted to sell out of the estate, any land you wanted to get rid of, anything you took in, any debt you had to be paid, had to be approved by the court. So you would have filing fees, you'd have to get the judge's signature.
They are getting more strict on that here.
Okay, actually, but anyway, about 10, 15 years ago, they said, that's not fair, because the court wasn't doing anything, but just signing it. I mean, they weren't, so they allowed, if you put in your will that you want independent administration, or if after you die, all of your heirs agree that your estate can be administered independently, then your executor can go about doing all those things without constantly getting court approval, putting it in the paper 2 times, all that kind of stuff.
And we generally
So
draft
It
in,
saves a lot of money,
It
and a lot of time.
it does, and we generally draft in provisions waiving things. We'll have people join in petitions to the court where all the interested parties join in, asking the court to waive. In the past, that's never been an issue. With a lot of recent fiduciary litigation in Mississippi, that has come on the front burner, and a lot of chancellors are not waiving, even in the will or all the heirs say that we're willing to waive those provisions. But it really depends on the chancellor. But that is definitely something that you take into consideration when you're drafting those type of issues.
Yeah, it's not set up the same way, but it's kind of working.
The other 49 states,
Yeah. Yeah.
Any other questions before we move forward? Okay. What do we have that we need to cover? I was 15 minutes.
on those, I think we kind of covered everything. The one thing about power of attorney and advanced healthcare directive that I would just kind of point out is those are very good to have in place, not just for the documents themselves, but it's also a way to sidestep the issue sometimes of having to have a guardianship set up with the court if someone's incapacitated, and having to have court approval for everything that you're talking about and having annual accountings and things of that nature, if those documents are in place. And you can also select a person that you would choose if things came to that point that would be the guardian over you. And so once again, it's just about making your choices before someone else makes them for you.
I guess one point back on these documents and the trust that I was thinking, that the question came up. Being a trustee, that's a real important role, and there's a lot of responsibility that goes along with that. A lot of people
Think it's a privilege?
think it's a privilege, and it's really a burden. And I really can't emphasize enough that whoever you pick, it needs to be a lot of thought given to that. And whether it's a corporate trustee, individual trustee, typically if it's an individual trustee, it's a lot for that individual to maintain, a lot to do, a lot to keep up with, accountings, management of assets and things of that nature. Corporate trustees, not that I'm promoting any corporate trustee, but they're sometimes set up better to manage that. Now, we can do both, or we'll have it where you have the corporate and individual trustee work together. Corporate handles the accounting, the taxes, that. The individual determines, do they really need this money for whatever it is they need. But it's complicated. And then another thing, I guess, from a trust, and this is getting off in weeds a little bit, I think, but trusts you have tax accounting. Trusts are taxed certain ways when it comes to income and principal. From the trust accounting, not tax accounting, but trust accounting under state law, that's not the same. Income under trust accounting cannot be paid out to beneficiaries under certain circumstances when it relates to oil and gas. You can't pay out all of the revenue from your oil and gas out of the trust, unless there's some proper drafting, assuming whoever's drafting the trust instrument knows what they're doing. If they don't, state law says you accumulate a lot more of the income. Law changed last year. But to make it simple, let's say you want to pay all the income out of the trust to the parents. And if it's not drafted properly, you're not going to pay out but about 60% of the income, or 70%, 30 or 40% is going to stay in the trust, and the trust is going to be taxed on it.
So that's just another reason you don't do self-drafting, and you make sure that you're talking to a professional, and not just a professional, but a professional that is proficient in the area of law that you're looking at.
And so after $12,000 in a trust, you're in the 39.6% tax bracket. Well, you gotta make a whole lot more than that if you're an individual before you're the 39%, 39.6% tax bracket. So those are just issues kind of in the peripheral, but they're significant that just people need to be aware of when you get into this type of planning. Now, over in the oil and gas, we've talked a lot about the mineral interest, but the surface owner, there are a lot of issues there as well. I mean, you've got your EPA and the DEQ issues, you've got the pits, you've got the runoff, you've got the pipes, you've got the roads, you've got all of these. Whoever has the surface is the one that's going to be left with whatever it is when the day is over. So the mineral owners don't really care if they dump a lot of the sludge and everything out on the ground, because they don't have that liability. And it's the surface owner that really needs to be aware of the long-term liabilities they may have, especially, and I think most of these operators are pretty good around so far anyway. But you've got that issue. The pad's going to be there. The well bore hole's going to be there. You hope they plug it in when it's over. You hope they're not putting stuff underground you don't know about. But that's something that seems to be overlooked a good bit, is the surface owner's responsibilities at the end of the day. Everybody's kind of excited about the revenue stream, but that's one thing that I think is something that everybody needs to be conscious of. And then another, and we mentioned this earlier, is the valuation. If we're gonna do something, this is the time to start thinking about valuing the assets. What are you gonna give away? How much you gonna give away? Do you wanna start making gifts of $14,000 a year to children or other heirs? You wanna give away $5 million. You wanna put it in an LLC. How do we best start going forward to determine most economically to transfer assets now as opposed to later? Because that window is going to close at some point in time, if it continues to grow like it appears it's going to for at least a short time. And I'm sure y'all have seen, after about a year or two, I mean, it drops way off and then levels. Now the question is whether or not with these 2,000 acre units, you know, this well may last for 30 years, so they only drill one well on that 2,000 acres and maintain the lease, and they never put any more wells on it. Time will tell how that's going to play out. But conceivably, you know, I'm sure y'all have heard, I mean, you know, they can put multiple wells on these 2,000 acre units. And if they did it all in 15 years, then there's going to be a lot of money coming in 15 years. So that would even compound this whole issue of valuation. But if they don't do it for one well every 30 years, then the valuation issue is not as great. So there's just a lot of planning that goes into that as well with respect to this type of an asset. And then the other thing is the issue, the deeds and the division orders, and then the ownership interest and these leases, and being, well, I guess making sure they all seem to match up and tie together. I know we're having some difficulties with some of these at this point in time, just trying to get
Everything to match up. You know, when there was back in the 1940s, the United States during the war took a lot of land back. And then at the end of the 40s, they gave it back to the landowners. And we're having some issues with the legal descriptions matching up and making back what they had. And, you know, it's just kind of a tedious process, figuring out what the landowner had then, what they have now, how it passed, and everything meshing.
And it could be
Matching
one,
up.
right. I mean, it could be one deed in 42, the same land in 43, the same land in 48, and say 54, and you would think the deed would read the same.
And
And
if any of y'all are involved in the George Hunt Trust,
it's
that one's been fun too. I mean, that's been interest all over, but I think we're.
same thing. I mean, it's very difficult to follow some of this, and you wonder what's going on and why it's not the same description, and then some of them seem to overlap, and so that's another, just something to be aware of, and hopefully you don't, well, I think probably just about everybody's got mental interest around here, have got issues with some of, just because how the conveyance is over the years.
Yeah. And that's why it's, if possible, it's best to keep up with it on the front end, you know, kind of do a little research or plan, figure out what you have, you know.
And what we've advised the clients is that we do it. I mean, not just rely on the oil and gas, the operators.
I've had some recently, but
They
I
just missed
submitted
it.
documents to, and they said that didn't come up in our land search, and they had to go send land and back out to re-go the other avenue, because there was a cloud on the title they didn't know aware of. So just plan now, and I know y'all have gotten so much information all over. It's not that complicated. You have to just get together what you know about and then talk to people that can help you along the way. It's just important that you do that now and not keep putting it off.
Just like everything else, starting the process. Big thing, just getting started. Now, any other questions?
And we'll stay afterwards as well if anybody wants to talk about anything.
Or anything, you know, that we did cover. I mean, there's a whole lot more out there with respect to this. And yes, we're glad to stay. If anybody has any questions afterwards or now.
Well, thank y'all. Yeah, thank you.
Thank y'all.